Morning, ladies and gentlemen. Okay, are you ready to proceed?
Yes, Judge.
I'll recommend not here.
We're taking one out of
In a moment.
Got the attorney here, okay?
Wait. Is the attorney coming?
No, but he's not here.
He's coming?
Which case do you,
No, I just. He's not gonna go forward. He's gonna do it. His attorney's friendly.
okay, let me. The cases that you wish to call out of turn are Suarez.
Yeah.
Okay. Okay. I'll go back into recess. I'll allow you to make your phone call. You're welcome. right, good morning, ladies and gentlemen. Here from Magistrate Docket. And today is January 11th. The first case you wanted to address was Lieutenant Morris. Good morning, Mr. Morris. How are you?
Good morning.
Morris, can you hear me?
Yes.
Ma'am, you've been charged with 1 count of battery. I will find probable cause to detain you.
I'm sorry?
Ma'am?
Yes.
I will find probable cause to detain you, ma'am. And does either side have an argument in reference to bond?
Your Honor, I would just advise the court, she has no criminal record. Would just be asking for, based on the level of violence, a $1,500 bond, no victim contact.
Judge, I could tell you that she does work as a skincare specialist with the amount of, she lives at that place, but she lives alone. The victim doesn't reside with her. Rent is about $1,500. She only has about $1,500 saved up just for the rent. I would just respectfully ask the court to set a $1,000 bond. I would also ask the court to sign an order to allow her to access her property. She was arrested. She does have $100 in cash on her. She would be using that money towards her bond. I would ask the court to allow her to access that money so she can post bond.
Is the money holding the evidentiary value?
I'm sorry, Your Honor?
Is the money that's been taken into custody have any evidentiary value?
None that I can see.
Okay. Ma'am, I will place you on a $1,500 bond. Order no contact. You shall not be able to possess any weapons, but you also may have access to the currency that you have it's in the custody of the Broward Sheriff's Office. So no contact with the victim. That means no indirect, no third-party contact, and no contact via social media or telephone. You understand that, ma'am?
Yes.
Okay. Good luck, ma'am.
Judge? Judge?
Yes.
I'm being asked by the deputies if we could call a gentleman here in custody out of turn.
Mr. Romero,
Eric
good morning.
Abraham on page 26. Good morning.
You're requesting to call Mr. Abraham.
Deputy advised me if we could call him in order to address him.
Hector, he has private counsel.
Oh, he does? Okay,
Yeah.
so
Yes,
we'll
Mr.
wait
Romero.
for
So
private
we're going
counsel.
to hold for his private counsel to arrive.
Thank you.
Okay, the next case was Suarez Ramirez. Is that the case? Is that the case you wanted to address? I pulled it out of turn because
Yeah.
it was the one.
All right,
Okay.
I can handle that right now.
All right, North Broward. Rory Suarez.
Yeah, it's North Broward, Your Honor.
Good morning.
Good morning, sir.
Good morning, sir.
Good morning. How are you, sir?
Doing well, thank you. And yourself?
Very good.
Sir, 1 count of battery has been presented against you,
Oh, no.
and I will find probable cause to detain you, sir. Is there any argument as to bond conditions?
Yes.
Hold, sir, let me speak on, if you allow me to, let me speak on your behalf. You don't have to say anything.
Your Honor, I can tell you as far as his criminal record in 2010, he pled out domestic violence battery by strangulation and battery. He violated probation, was sentenced to 43 months state prison. Additionally, in 2009, battery on a law enforcement officer, tampering with evidence. He violated probation in that matter, was sentenced concurrently to 43 months state prison. Your Honor, based on his prior record and the allegations in this matter, I'm going to be asking for a $5,000 bond and no victim contact.
Your Honor, I could tell you that he's a resident of South Florida all his life. He works at Brio at the Pembroke Gardens in Pembroke Pines. He's responsible for paying the bills in the house. He was residing with his mother, but he does have a place to stay
He's
separate.
the alleged victim in the case, correct?
Correct, Judge, but he does have a place to stay separate and apart from her. He does have family in South Miami. His his grandmother and father live there. He went to Chapel Trail Elementary. He does have substantial ties to the community. He's gainfully employed with Brio. He can make up to $200 a night. He would be relying on his grandmother to bond him out of jail. I would ask the court to set a $2,500 bond in the matter.
And he'd be residing in South Miami if he posted bond, correct?
Correct.
So his ties are primarily to Dade County and in particular the South End.
Right, but he does work in Broward County. He does have a job at Brio at the Pembroke Gardens in Broward County.
And respectfully, I will set bond at $5,000. Order no contact with the victim. And I am finding probable cause. Finish also not possess any weapons. Sir, do you understand what no contact means?
Yes, sir.
Okay, that's no contact at all. Not direct, indirect, third party, electronic, telephonic, social media, any means at all, sir.
By all means, I don't want any more contact.
Okay, I appreciate
I was
that.
the one paying for her. I don't want any more
Sir,
contact.
you don't have to say any more.
You don't have to talk about the case, sir. Okay? Good luck, sir.
Thank you.
All right, the next case you wanted to address was Bryant. All right, we'll find probable cause to detain. Well, first, where is Mr. Bryant? Oh, there we go. Mr. Bryant.
North Broward, Your Honor.
Good morning, sir.
Morning.
Sir, you've been presented with 2 counts. One, there's a writ of arrest for failure to pay child support. And there's also 1 count of domestic violence. On count 1, I will find probable cause. And you have a previous bond set at $442 on count 2. In reference to bond.
Your Honor, in 2000, defendant was convicted of aggravated battery, great bodily harm, sentenced to 38 months state prison. 2000, possession of alprazolam and theft. He received the same sentence concurrent. 91, burglary of a structure, a year and a day state prison. Based on his prior record, the level of violence and the alleged threat to kill in this case, I'd be asking for a $6,500 bond, no victim contact.
And defense?
Judge, he's a resident of Broward County, specifically Hollywood, Florida, all his life. He currently lives in a mobile home which he owns. He's been residing at that place for 2 years. That mobile home is paid for. Its worth is about $7,000. His bills amount to about $550 a month. He had a broken shoulder about a month ago. Prior to that, he was working as an electrician. He doesn't have income coming in due to his injury. He does own a truck worth three grand. Be relying on his parents to bond him out. Most they can afford is up to $500.
Okay. Court is concerned with not just the violence used, but the threats of future harm. Specifically, the future threat to kill. I will set bond at $10,000 on count 1, and count 2 previously had a $442 bond set on that as well. There'll be no contact with the victim. So there's no direct, indirect, telephonic, electronic, or any other means, sir. Do you understand that?
Yes, Your Honor.
Okay. Thank you, sir.
Sit.
Okay. And the next case, Fletcher.
Khalif Fletcher, he's president at Maine. Come on up, Mr. Fletcher.
Good morning, Mr. Fletcher. Can you hear me, sir?
Good morning.
Good morning, sir. Sir, you have two counts that were presented against you. One is battery, and the other count is contempt of court for violation of an injunction for protection against domestic violence. And I will find probable cause on both counts.
With regards to Mr. Fletcher, the only issue with regards to count 2 is that was he ever served with an injunction?
Your Honor, he has a no contact order from a pending battery against the same alleged victim.
That case number is
16-10-703 MM10A.
and when was the no contact order issued on that case?
Your Honor, it was issued at the time of his first appearance and dated November 30th, 2016. It was issued by Judge Davis.
Okay, so it would have been at magistrate hearing, so he would have received notice of that. So I will find probable cause and as to conditions of release.
Your Honor, in addition to the pending case, one moment, Mr. Fletcher was arrested last year for aggravated battery against a pregnant victim, same alleged victim. That charge was dropped. 2013 grand theft auto, 2013 grand theft, petty theft, criminal use of personal identification information. He violated probation. Resisting without violence, 2013. Resisting without violence, 2013. Violated probation. Resisting without violence, 2013. Based on the 2 prior arrests, one of which is pending for violence against the same alleged victim, and it looks like from what it reads here, his refusal to follow court orders. I'm going to be asking for a $15,000 bond on count 1, a $10,000 bond on count 2. Should he be eligible for release on these charges, I'd be requesting he be supervised by pretrial release with a GPS monitor.
Judge, in speaking with Mr. Fletcher, he's been residing in South Florida for the past year. He just obtained employment. He's working at Burger King. He's making $9.30 an hour. Financially, though, his resources are very limited and scarce. He has no money to make, no property. He will be living separate and apart. He'll live in Margate with his brother. Judge, he does not know the financial resources of his brother. We'd be asking you to set a reasonable bond as to count 1 and count 2.
All right. The court is concerned with the actions, also the previous violations of court orders, specifically the violations of probation, as well as the alleged violation of the order entered here. So I will find probable cause on count 1 and count 2, and I will set bond at $5,000 on count 1, $15,000 on count 2. In order, no contact with the victim, and the defendant shall not be allowed to possess any weapons if you should post bond. Sir, do you understand that there shall be no contact from this point forward?
Your Honor, I mean, the only thing is the fact that, like, I'm already have my lawyer getting the contact order lifted. We have already a statement from the victim saying...
Sir, right now I'm ordering no contact. Do you understand that? Yeah. As of today, I'm ordering no contact. Unless another judge, your assigned judge, rules otherwise, I'm issuing a no contact order. So you shall have no contact, direct, indirect, telephonic, electronic, third party, any kind of communication with the victim. Do you understand that, sir? Okay, if your assigned judge rules otherwise, that's a different story, okay?
Yeah.
All right, sir. I do wish you good luck.
Thank you. Thank you.
And state I did note the request to place a defendant on pretrial. I did not, because of the monetary bonds, I did not place him on pretrial.
Yes, Your Honor.
Okay, and we don't have Mr. Pillay here as of yet. All right. John Torchon?
Mr. Torchon, come on up, please.
Good morning, sir.
Good morning.
How are you? Sir, you have two counts that have been presented. One is assault, and the other is resisting without violence. We'll find probable cause on each count, sir. And that's the conditions of release.
Your Honor, he has no adult priors. He does have an outstanding warrant out of Dade County for a failure to appear in court on a misdemeanor cannabis charge. Based on that failure to appear and the allegations in this case, I would just be asking for a $8,000 bond, no victim contact.
Judge, and speaking with Mr. Torchon, he's been residing in South Florida his whole life. He is 19 years old. He does not work at this point. He just obtained employment. He starts Friday at Walmart. His expected salary is going to be $10 an hour. He also attends Hallandale Adult. He's working on getting his high school diploma. Financially, has no money in the bank, no property. The alleged victim is his mother. He does not know who is going to possibly be able to post his bond, Judge. We'd be asking for a reasonable bond as to Mr. Torchon.
As I've indicated, I will find that there is probable cause, and I was actually thinking of a higher bond based on the comments made after the incident, specifically that he indicated, the allegation is that he stated he would make the victim suffer. And there was a juvenile sitting in the front passenger seat when this incident took place. I will set bond at $1,000 on count 1 and $100 on count 2. And no contact with the victim. The order is reviewable by the trial court. No contact, sir, means no direct, indirect, third party, electronic, telephonic, or by any means. Do you understand that, sir?
Done. Don't come up here with an attitude.
Do you understand?
Do you understand no contact, sir?
Okay, yeah.
Okay. You're to have no contact with the victim in this case. All right, I have Anthony Williams.
Mr. Williams, come on up, please.
Good morning, sir.
Good morning.
Sir, I will find probable cause to detain you. You've been charged with 1 count of battery.
Yes, sir.
I'm finding probable cause. Are there any arguments as to conditions of release?
Your Honor, first, Mr. Williams is currently on release for charges of fleeing and eluding law enforcement, reckless driving, and operating a vehicle with no valid driver's license. In 2011, he was arrested for an aggravated battery against a pregnant victim. That was dropped. 2007, disorderly conduct. Your Honor, based on the allegations in this case, his open felony offense and the prior arrest involving violence, I'd be asking for a $2,000 bond, no victim contact.
Judge, and speaking with Mr. Williams, he's been residing in South Florida his whole life. He is 31 years old. He's currently employed. He works for a moving company. He's been working for that company for the past 6 months. He makes about $11 an hour. Financially, he has no money in the bank and no property. We'd be asking you to set a reasonable bond and consider Mr. Williams' financial resources.
The fleeing and eluding, is that in Broward County?
Yes, Judge.
That case number is?
14-7905 CF10A.
And you said that case is currently pending?
Yes, it is.
Who is the assigned judge?
I'm showing Judge Bober. I'm actually... One moment, Judge. Yeah, I mean, frankly, it looks like there was an arraignment scheduled for July 8th, 2014, and nothing, as far as what I can see in Odyssey, nothing after that. I don't know what happened.
I'm sorry, the arraignment was set when?
July 8th, 2014.
2014, and no action since then.
No, the only thing I see is that Mr. Williams sent a letter to Judge Bober, and it was entered into the system December 16th of last year.
Okay, that is extremely unusual.
Yes.
I will set bond at $1,000. And I have found probable cause, sir. I'm going to order no contact with the victim and no return to the property. And you understand what no contact means, sir?
Yes, sir.
No direct, indirect, third party, electronic, telephonic contact by any means, sir. You understand that, sir?
Yeah.
Okay. All right. Good luck, sir.
Thank you, Judge.
And we have Gardner.
Camoli?
Camoli?
Pinoli, right? No, Pinoli. Gardner.
I apologize for mispronouncing your name, sir.
All right.
Your bond is $1,000.
So one count of assault has been presented against you, and I will find probable cause. And are there any arguments as to conditions of release?
Your Honor, Mr. Gardner does not have any criminal record. That being said, the allegations in this case, one, the actions alleged, and then the alleged threat of breaking victim's neck, I'd be seeking a $2,500 bond and no victim contact.
Judge, in speaking with Mr. Gardner, he's been residing in South Florida his whole life. He is 21 years old. At this time, he's unemployed. He's looking for work. He just lost his job. He was working in construction. He was getting paid about $12 an hour. He's a graduate of Dillard High School, class of 2013. This is his first arrest ever as a state verified. He is a registered voter here in Broward County. He has a girlfriend. His girlfriend is 2 months pregnant. That's why he's looking for work, trying to get finances in order to help her with the pregnancy, Judge. Considering his lack of criminal history, his lack of financial resources, his strong ties to the community, we'd be asking you to consider a $1,000 bond, Judge.
Is he a candidate for pretrial release?
If the court orders us to take him, we shall. But other than that, Your Honor, we don't make recommendations for persons charged with domestic violence.
Okay, I will set bond at $2,000 and order no contact with the victim and no weapons.
You will be charged with everything with the post court cost.
So do you understand what no contact means?
Yeah.
Okay, no direct, indirect, telephonic,
Do you have any
electronic
children?
communication by any means, sir. Okay, no
All
social
right.
media or anything.
Judge, may I have 1 second to inquire with Mr. Gardner one question?
Yes, sir.
Judge, one request. His father is the alleged victim. I know his mother also lives there. All his belongings are there. He knows he has to have no contact. Would you allow him to go with law enforcement?
The name of the victim is Daphne Gardner.
Oh, okay. The mom. So he cannot have any contact with the mother. He now understands that.
Okay.
What he's asking and requesting is, can he go accompany with law enforcement one time to retrieve all his belongings, which he needs?
Okay. He can, with law enforcement accompaniment.
Yeah.
I need a short order to that effect.
My colleague in courtroom will provide you one.
Your Honor, I
Thank
think
you,
it's
Judge.
actually, it's actually part of the no contact order that you sign, I believe.
Okay. See the next paragraph?
I think it's in paragraph 5.
Ah, That is correct. So there's no separate, so it says the defendant may, through a third party, arrange to retrieve his personal clothing. The only thing I'm adding is that he must be accompanied by law enforcement.
Thank you, Judge.
Okay, and James Hancock.
Come on up, please.
Good morning.
I guess this could go right here. It's really just caught up with it.
All right, so you have an out-of-state hold,
Word out of another state.
and it's been set at no bond, sir. You understand that?
Yes, sir.
Okay. Crystal Izzo.
Judge, I've been informed she bonded.
Okay. Jean Lorello.
North Broward.
That's North Broward.
Good morning, ma'am.
Good morning.
Ma'am, you've been charged with one count of petty theft. I will find there is probable cause to detain you.
Case number 16-144-250, aggravated battery with a deadly weapon. Case of a court finding of probable cause to the aggravated.
And that case number again, I'm sorry, is 16.
144-250. Aggravated battery with a deadly weapon.
Okay. Any arguments based on that?
Judge, is the court inclined, what I would say is that she's charged, the alleged violation is a petty theft. I believe it was at a grocery store. Does
Yeah.
it seem that the items were returned. They're not, the allegations before the court today are not of a serious nature. The court does have other options. They can place her on a monitor. They can place more strict.
It sounds like she's currently being supervised by a pretrial.
No, I understand, but if there's different, there are different levels of supervision. The court can increase if she's on standard level. The court can go to level 2 or lockdown level 1.
All right, state.
Your Honor, just to advise the court, Ms. Lorello was in drug court from 2014 until she ultimately pled the case out last year for possession of cocaine. In 2009, she was in drug court for possession of cocaine, had the charge dropped after a successful completion, and a DUI in 2009. I'm fine with the $100 bond on the theft. As far as the pretrial issue, that's really in the court's discretion.
Okay. On the case before the court today, I will set bond at $100 on case number
Thank you.
16-14425-CF10A. I will revoke your bond and issue a no bond hold, ma'am. That order is reviewable by the trial court.
That's it. Let's go to room number 1.
Grant Thomas.
Crane Thomas, come on up, please. She's here, President Main Judge.
Good morning.
Good morning.
How are you, ma'am?
All right.
Ma'am, you have one count of violation of community control. Bond has already been set at no bond by your assigned judge.
Thank you.
Okay. And you have a hearing, it looks like 1/17/17 at 8:30 a.m.
117 at 8:30 a.m.
Danielle Williams.
Miss Williams, come on up, please.
Decline PD.
Judge, Miss Williams declined the services as public defender.
Good morning, Miss Williams. How are
Good
you?
morning. Good.
Ma'am, likewise, you have a violation of community control, and it looks like no bond was set for your case as well. Okay? You do have a hearing on 117 before your assigned judge.
I just said it was the phone number.
Okay.
Okay. Thank you.
Mary Jones.
Miss Jones, come on up, please.
Ma'am, I will find that there is probable cause to detain you. Is there any argument as to conditions of release?
Your Honor, first, just advise the court, 2008, Ms. Jones is convicted of delivery of cannabis, 21-month state prison. 07, she was convicted of aggravated assault of deadly weapon, violated probation, sentenced to 21-month state prison. 06, uttering a forged instrument and grand theft, violated probation, 21-month state prison. Based on her priors, and Your Honor, frankly, the alarming allegations in this case where it appears that she provided transportation to and away from a scene where two gentlemen shot a victim 6 times, and it would certainly appear based on the evidence that it was her intent to provide assistance to these two men to shoot the victim. I'd be asking for a $150,000 bond, no victim contact. Should she post her bond, pretrial release with a GPS monitor level 1, Your Honor, to act as a further deterrent to ensure that there's no contact with the alleged victim.
And defense.
Judge, in speaking with Ms. Jones, she is 32 years old. She's been living in our community for the past 25 years. She is employed. She works in customer service. She just started. She makes $10 an hour. She lives in Fort Lauderdale with her grandmother. She's been residing at the same residence for the past 23 years. She has one child, a newborn, 4 days old. Right now, the child is being taken care of by the grandmother and her aunt who live at her residence. Judge, financially, she has no money in the bank. Her only property is she owns a vehicle, a 2009 Nissan Sentra with approximately 100,000 miles on it. Judge, considering the circumstances, her limited financial resources, we'd be asking you to consider a $20,000 bond.
And the state is asking for 150. Is that correct?
Yes, Judge.
All right, I'm going to set bond at $50,000. I'm also going to order pretrial level 1 upon release. And I did find probable cause. I will also issue no contact with the victim, no contact with the co-defendants in the case. Ma'am, do you understand what no contact means?
Yes, sir.
Okay, there's no in person, no contact through a third party, telephonic, electronic, social media, any means at all, ma'am. Do you understand that?
Yes, sir.
Okay, ma'am. And that's for the victim and the co-defendants in the case.
Okay. Not a problem.
Level 1, yes, ma'am.
Is the court finding her indigent, or she pays $5 per day monitor?
I did not find her indigent as of yet.
I'm fine if she qualifies for the PD then.
Okay.
Perfect, all right.
So that will be reviewable by the trial court. Good luck, ma'am. Bailey, first name Lolietta.
Lolietta Bailey? She's here present, Judge, at Maine.
Decline PD.
Oh, Judge, I've been advised Ms. Bailey declined the service as public defender.
Good morning, ma'am. How are you?
Good morning. Good. You?
Ma'am,
You work?
you understand you have two counts that have been presented against you?
I'm sorry?
You understand that you have 2 counts that were presented against you?
Right.
Okay, those two counts are possession of a fictitious unlawful driver's license, as well as operating a motor vehicle without a valid driver's license. You understand that?
Right. Yeah.
Okay. The purpose of this hearing is to determine whether or not there's probable cause to detain you and conditions of release if appropriate. And I am finding probable cause on both counts, ma'am. Okay?
I'm sorry?
I am finding probable cause on both counts. And I will set bond at 1,000 on count 1, 500 count 2.
Do you owe anybody any money? Credit card, I'm sorry?
Okay.
And that's each?
What? No, $1,000 on count 1, $500 on count 2.
Okay.
Okay? Good luck, man.
Thank you.
Talia, roll.
Judge, I have a probable cause argument. That's count 1.
Roll.
She's coming up.
Oh, okay. Just want to make sure.
Come on up to the throne.
Good morning, ma'am.
Good morning.
As to count 1, I believe you had an argument.
Yes, Judge. Nowhere in the nowhere in the probable cause affidavit, even though I would say there's PC for possession of cocaine, but the officer charged of possession with intent to sell or deliver, manufacture or deliver cocaine. There's nothing in the probable cause affidavit that indicate the officer would say through his training and experience that the drugs were packaged in a way to be sold. Were packaged in a way to be sold on the streets, that they were separated individual baggies, a scale, anything indicated that she had the intent to sell, deliver, other than possess.
Dave?
Your Honor, I'm fine with the finding of PC for possession of cocaine.
All right, I will find probable cause for possession of cocaine on count 1. And I will set bond at $1,000. But ma'am, on count 2, you have a warrant. And that is a capias, and there's a no bond hold on that warrant. You have a hearing before your assigned judge on 1/17/17 at 8:30 a.m.
Thank you.
Good luck, man. Brianna Mateague?
North Broward.
Good morning, ma'am.
Next two in North Broward.
Ma'am, you have a violation of probation that has been presented, and it looks like the
Yes.
assigned judge has issued a no bond hold on your case.
Okay.
You do have a hearing on 1/12/17. That is tomorrow. Okay?
Tomorrow?
You
I
have a
go
hearing-
before my judge?
Yes, ma'am. You have a hearing tomorrow before
Okay.
your judge at 9 a.m.
Okay. Okay, thank you.
You're welcome.
All right. Bye.
Latoya Grant?
That's also
North Broward.
Good morning, Mr. Grant.
Good morning.
Ma'am, likewise, you also have a violation of probation that has been signed by your assigned judge. And I have read it, and I do find it to be legally sufficient, and the bond has been set at no bond. You also have a hearing set before your assigned judge on 1/17/17 at 8:30 a.m.
117, so that's what, next week?
January 17th, yes, ma'am.
Next week?
Yes, ma'am.
Okay, that's it?
Yes,
You said
ma'am.
117, right?
And you're currently being held no bond pursuant to that judge's order.
Okay,
Good luck, ma'am.
that it? Thank you.
You're very welcome. Derek McDowell?
Your Honor, this is a municipal ordinance out of Hollywood. Mr. Shade would be the attorney. If he's indigent, Mr. Shade would be the attorney.
So what facility do we have the defendant
And then the go.
at? Mr. McDowell? Morning, sir. I will find if there is probable cause to detain you.
Yeah, bonded.
Are you bonded?
No, the other.
No, somebody else.
Okay. I will find that there's probable cause to detain you, sir.
Marcus
Okay.
Jackson?
One count of a municipal ordinance violation. It's lodging on private property.
Do you have an attorney?
Okay. And I will set bond at $25, sir. You understand that?
Yeah.
Sorry, sir.
I said, yeah.
Sign where she access the
Good luck, sir.
Judge, with the court, the only fear I have is a case like this. If he is indigent, languishing in the system, will the court appoint counsel provisionally? Mr. Shade handle these matters.
Do you have any children?
Don't matter. That's what we want
I
y'all
haven't
to
heard
do.
anything as of just yet.
Will the court make an inquiry, Judge? Or the court does have the option of resolving the case if the court is so
Mr.
inclined.
McDowell? Mr. McDowell?
McDowell.
He's coming back in, Judge.
Okay, thank you.
So you can, Mr. McDowell?
Young man.
Individually, individually started to start with the rules.
He's coming back up, Judge.
Thank you, Mr. Romero.
I want to resolve.
Okay, can we please place Mr. McDowell on the road?
Repeat it. Do you owe anybody any? No.
Just like
Zero.
this.
Date of birth.
What's that? Yeah. I don't know if I can place anyone under oath.
Sign, frame, address, city, figure, code, phone number. Sign and frame.
Mr. McDowell, can you raise your right hand, please?
Mr. McDowell, can you raise your right hand?
Do you swear to tell the truth?
I do.
And can you state your name for the record, sir?
I do.
Can you state your name for the record?
Cedric McDowell.
Okay. All right. Sir, you can place your hand down, sir. Sir, do you have an attorney?
No.
Can you afford an attorney?
No.
You want to see if you qualify for a court-appointed attorney?
Yes, I can.
Okay. Do you have any assets?
Excuse me.
Do you have any assets, any property?
Are you on probation? Out on bond?
No.
Any case?
The vehicle, what kind of vehicle is that? Do you own that vehicle?
Yes.
I told you press down hard. I don't know how many times. That's why we.
Was it paid for?
Yes.
And how much is it worth, sir?
That's what they.
I'm not sure.
Okay. And what year is the car, sir?
2005.
2005 BMW? Okay. And do you have any money in the bank, sir?
No children?
No, I don't have no money.
Do you have a job?
Take medication?
I'm a student at MDC.
You're currently a student? All right. I will appoint Mr. Shade to represent you, sir. So I will appoint a court-appointed attorney to represent you. All right. Thank you, sir. All right. This is Mr. Pillay here.
Good morning, Judge. I'm sorry. I was sent this morning and I'm in trial observing.
Yes, sir. Okay, this is on Eric Abraham.
Correct, Judge. Judge, it's my understanding that the...
Mr. Abraham's coming
I
up.
just want to make sure that he gets to the podium.
Yeah, it seemed like he really understood.
Mr. Abraham, good morning, sir.
Good morning.
Sir, you do have you have an attorney present in court.
Huh?
You have an attorney present in court for you, sir.
Mr. Abraham, Mitch Polay. I
Mr.
spoke to your
Polay.
parents. Hey, good morning. Listen to me. The only thing I'm asking you to do is not discuss this with anybody. Do not discuss the facts on the phone. Do you understand that?
Yes, sir.
Okay, and you're not to give a statement to anyone. You understand that?
Yes, sir.
Good morning, sir. Good morning, Judge.
Good morning.
Judge, it's my understanding that the state is direct filing.
That's correct, Judge. The case
On
has
this
been
charge.
filed. Charges have been filed. Michael Harwitz on behalf of the state. Judge, we filed 1 count of aggravated fleeing causing death, 4 counts of aggravated fleeing with serious bodily injury, vehicular homicide, reckless driving causing serious bodily injury, 4 counts, no valid driver's license causing death, 4 counts of no valid driver's license causing serious bodily injury, and grand theft auto.
Okay, and do you have a copy of the charging document?
Sure.
I can print out a copy.
Well, here's a. I don't have an extra copy of that information, but.
Okay, I do have an order from Judge Robolo.
But I do have a copy of the information before it needs to review that.
Okay, and as to probable cause, so we'll find that there's probable cause to detain you on each of the counts presented. That being said, Mr. Pillay, any arguments as to conditions of release?
Judge, my only statement that I want to bring forward to the court at this particular juncture is the fact that the child does have ties to the community. I've spoken to his parents. His parents have been in contact with me. They asked the court to set a standard bond in this particular case. These are bondable offenses. And I don't think the state could tell you otherwise.
And
Judge, just so the court's aware, he has an extensive juvenile record, including he absconded in 2015. Then I'll just go ahead and tell the court his juvenile record goes back to 2012. He had a simple assault.
Judge, I hate to interrupt, but everything is being streamed online, and I believe that everybody could hear his juvenile record. It will be public matter, public record.
That's true, Judge. Thank you. I was just about to say that, Judge.
Okay, the court is entitled to look at the juvenile record.
Sure.
Do you have a fish sheet?
Yes.
No paperwork.
He has multiple priors, including first-degree punishment by life
I was
priors.
just asked that you not mention anything right now.
In reference to the specific crimes, I don't feel there's a need to list them on the record. However, for the record, the court has reviewed the face sheet, which includes juvenile priors that are also on the NCIC. This provides a little bit more information. Most notably, the failure to appear and the history of failure to appear and absconding. So the court is concerned with that. And let's see, in reference to bond.
Judge, I'm going to ask the court as to count 1 to set a bond of $200,000. As to counts 2 through 5, $75,000 each. Count 6, a vehicular homicide, $100,000. Count 7 through 10, reckless serious bodily injury, $25,000 each. As to count 11, no valid driver's license causing death, $50,000. As to counts 12 to 15, No valid driver's license causing serious bodily injury, 10,000 as to each
I'm sorry,
count.
hold on, just for 1 second, because the packet that I have only has counts 1 through 8. And that's why I asked to see the charging document. Count 1 is aggravated fleeing with serious bodily injury or death. And
Mr. Green?
Counts 2 through 5 are aggravated fleeing causing serious bodily injury.
okay, it's presented as reckless. It's presented as reckless with serious bodily injury. Now it says filed. I see that.
At least mine had it to the side. If you go off the booking sheet, kind of gave the changes and charges. Where it said comments. As to what the actual charges are about.
Still making she handicapped. She handicapped.
On count 1, I will set bond at $200,000.
If I could just comment before, that in effect is 10 bond to no bond. I don't see a reason to set anything other than the standard bond. He does have ties to the community, his parents here, he's lived here his whole life.
Judge, obviously the extensive criminal history and additionally the facts of this particular case. And additionally, there's other special conditions that we're asking.
The other conditions would be?
Other conditions I'd ask is that it be fully collateralized, that it be level 1 GPS monitor, no drugs or alcohol in random testing, no driving, no contact with the co-defendants or the victims, surrender a passport prior to his release, not apply for a new passport, and no firearms or weapons.
Were you arrested by yourself? Do you have any children? They live with you? How many?
What is those conditions?
Judge, like I said earlier, the bond that the state's asking for is 10 years. There's no bond that asks the court to impose standard bonds. He's a child who's being direct filed. With respect to the conditions, Judge, I don't see the need for lockdown at that particular age. Court, if the state's asking for level.
I understand the argument and I appreciate the argument. Respectfully, I am concerned with the allegations as well as the serious nature of the offenses. I have looked at the juvenile record. I'm not going to go into detail about it, but I am concerned by that as well. But I am also concerned about the loss of life. And I will, as I indicated previously, issue a bond on count 1, $200,000.
Address, city, physical, phone number, email.
I'll set on counts 2, 3, 4, and 5. I will set bond at $50,000. And count 6. I will set bond at $100,000.
What is count 6? Because
Vehicular homicide.
it's not showing.
Person or viable fetus. And count 7. Starting at count 7. The state's recommendation
Will be $25,000 for 7 through 10, $25,000.
All right, I will set $25,000 on count 7, 8, 9, and 10.
Can you afford it?
That's to count 11.
50,000. No valid driver's license causing death.
There you go.
I will set bond at 25,000 on count 11
Okay. Yo. Just about required.
and count 12.
Counts 12 through 15, or requesting $10,000 for each account.
Yeah, that's kind of
That's no valid driver's license
Same
causing
argument I'm making
serious.
before, Judge. This is 10
You live along with family and friends.
All right, I will set at $10,000 bond on 12 through 15 and count 16
Count 16 is the grant that bond. I think there's already a bond set on
at
that.
1,000. Well, there's a recommended $1,000 bond, and I will issue the $1,000 bond on count 16. The order of the court, as it pertains to bond, is reviewable by the trial court. Obviously, more information will be available to the trial court than is available to this court today. So specifically, I'm going to write it on the packet as well.
Any mental problems?
I will ask,
When you were arrested?
I will order no contact with the victims or their families, as well as the co-defendants. And I will order the defendant surrender passport and not apply for a passport during the pendency of this case. No firearms or weapons. And should the defendant post bond, level 1 pretrial.
So, asking if you prepared an order.
Oh, I didn't. I don't have one. You need one? I can do it. Do you have one? Okay. No, I don't. Judge, we're also asking that obviously, even with level 1, that'd be no driving, no drugs or alcohol, random testing.
Do you have an attorney? Gonna hire your own, or do you want a public defense?
No driving.
Don't get one, I'm just putting it to you, is that what you want?
I'm not going to add any further conditions at this time.
Do you have any insurance? Live with you? What is your-
I didn't request that at this time.
Do you work? Would you take something?
Thank you, Mr. Pulley. You as well, sir. Mr. Horowitz. And do we have Nigel Rodriguez?
Mr. Rodriguez is here in Maine. Come on up, Mr. Rodriguez. Judge is a friend of the court. Mr. Rodriguez is going to inquire if you would consider resolving his case to time served.
Hey, good morning, Judge.
Good morning, sir.
Judge, it is. I know there are other facts in there.
Is he
going with us, or what's going on?
Mr. Romero?
No, he's
is
going.
in front of the court.
Well, I don't think he fully filled out the financial affidavit, but I believe he is, Your Honor. So, yes, he's going to go with us, Judge.
I'm not making an argument as to probable cause, Judge. There is probable cause there. I would just note that they recovered a pipe on him with residue. So I would ask the court to take that into consideration in resolving the matter.
That there's also a use? Is that what you're indicating? Okay.
It's not that they found multiple baggies on him. The residue they got was they scraping from the pipe that was found on him.
All right. And state other priors?
Your Honor, he pled out a resisting without violence before Your Honor, July of last year. He's actually out right now. He was arrested in late November for possession of cocaine, excuse me, cannabis, paraphernalia, resisting without violence. The state was unable to file charges and has to this day, at this time, has still not filed charges. He was ROR'd on those counts. Possession of cocaine, pled out July of last year, 270 days county jail. Another possession of cocaine case, same sentence. And possession of cocaine, 2015, he pled out July of last year also.
And the court is being invited to negotiations?
Yes, Judge.
Okay. I would be inclined to offer him 364 days in the Broward County Jail, mitigated by a 30-day SAP.
Let me consult with him, Judge. Respectfully, Judge, he does not wish to accept your honor's offer.
Okay. And Mr. Romero, just so you know, that was based on the facts of the case as well as the history as well, and the things I've heard today. But I will find probable cause on both counts. On each count, I will set bond at $100. Does he wish to be transferred to drug court?
I can ask him.
Because he might get transferred.
No, thank you at this time, Judge.
That's fine. Good luck, sir.
You're done.
All right,
Thank you.
Ednet Faustin?
Mr. Faustin?
Good morning, sir.
Good
morning, sir.
What is the girlfriend's number?
Sir, one count of misdemeanor battery has been presented against you, and I will find probable cause to detain you.
I'm sorry?
Any arguments as to conditions of release?
Your Honor, I'm just, he has a juvenile record. I'm just asking for the convenience bond to be kept in place with an order of no victim contact.
All right, is he still in school at, is he still in school? I'm not going to announce the school for the record.
He is in school, Judge.
Okay. Any arguments as to conditions of release?
At this time, no, Judge.
All right. I will set bond at $1,000 and order no contact with the victim. There's no direct or indirect contact, sir. No telephonic, no electronic. No contact by any means, sir.
Thank you, Judge.
Remain ace.
Judge, I've been informed of a request. Could you sign an order allowing Mr. Faustin access to his property to retrieve a phone number so we can call the person to bond him out?
For him to actually access the phone, I can do an order for one of your investigators to access the phone.
What I believe
It's
is with the order.
It's commonplace with Judge Davis that
Each judge may be different as to how they approach things, but I don't know if the phone holds any evidentiary value. That hasn't been expressed.
Yeah, and I think what it comes down to, if his phone's in property, I would imagine it doesn't have any evidentiary value. I would imagine the law enforcement would have held on to it. So frankly, I don't have an objection if they've turned the phone over to property at the jail. If it's not on property and the police have it, then it's really a moot issue.
All right. he may be allowed to observe his phone and access that number under supervision of law enforcement.
Yes, Your Honor.
So, all right. And let's see.
I'll give you right back. I'm just gonna scan it through.
Mr. Ace?
Mr. Ace.
All right.
I'll just scan it. Thank you.
So you have three counts that are presented. One is failure to register motor vehicle. One is driving with license suspended, first offense, and loading or prowling as well. I will find probable cause to detain you, sir. Any arguments as to release?
Nothing from the state, Judge.
Nothing from the defense.
Okay.
Mental problem?
Set bond at 0 on count 1, 100 count 2, 0 count 3.
Thank you, Judge.
And Mr. John Berry.
Mr. Berry's here present at main judge. Mr. Berry's inquiring also if you would consider being involved in plea negotiations and extending a time served offer to Mr. Berry.
Mr. Berry has a 2000 case.
You need a copy of mine? I'll send it to her. Thank you.
Yeah, no problem.
Yes, sir.
Mr. Romero, I don't have a physical file on this case, and the only probable cause affidavit is for the service of the warrant. So on a 2000 warrant, it wouldn't have been e-filed, right? I mean, it definitely wouldn't have been e-filed unless it was.
There's no way they pulled it from our
So
country.
at this juncture, I'm not able to access it. If you're able to, if we're able to retrieve it, I wouldn't mind taking a look at it on a second look.
I understand, Judge.
Okay. But the bond has already been set at $500.
Thank you, Judge.
There is we need to set a status. What division is this?
It's
To Solomon. All right. And we'll set a status on Monday. We'll set a status on Monday before Judge Solomon. And
Okay.
please make sure that this file is ordered for Judge Solomon. Thank you.
So the judge is putting you back on for Monday. So at that time, they'll have the police report, and then a different judge will consider whether or not to resolve the case for you. So you'll be back on Monday. Okay.
Okay, do I bail out or
Oh, if you bond out, you can bond out, of
can
course.
I get my access to my stuff so because I have the money in there?
Oh, okay. Let me ask for the order. Judge,
And my phone too.
Mr. Berry did advise me that he's going to plan on bonding out. He believes he has the funds in his property. Would you sign an order allowing him access to his property in order to retrieve the funds for him to self-bond?
State any objection?
I didn't realize they keep it.
And the phone as well?
He just needs to tell the deputy he wants to self-bond, and they'll let him access to his property.
I will allow him access to the currency in his property.
Thank you, Judge.
But he still has to be before Judge Solomon on Monday.
Here. Okay, let me explain that to him.
Okay. He has this, here. No, not in this courtroom. And before Judge Solomon. That's his assigned judge.
Okay, do you know what courtroom number so I can tell him right now?
I believe it's 353.
350. Okay, so they managed to get you a court date in front of your assigned judge, Judge Solomon, 353. Monday, you're going to have to be here in the morning. Wait a minute. Is Monday a holiday?
Oh, I apologize. Tuesday. Yes, it is.
Okay, so Tuesday.
Yes.
Tuesday morning, you're going to have to go to report to a courtroom at 8:30 in the morning, room 353. Let me write it down for him, Judge.
Thank you, Mr. Romero.
Thank you, sir. Solomon would be Tuesday. Yes, Tuesday. Room number 353. Be there at 8:30 a.m. Okay.
Very nice. Okay, who would I?
And
Thank you,
Bowen.
Oh, Judge, I've been advised he's a medical reset.
Will we set it for tomorrow? Okay. Cesar Lopez.
Mr. Lopez here, present at Maine.
Morning, sir.
Morning, Mr. Lopez. How are you, sir?
I'm good.
All right. Sir, you've been detained for one count of possession of cannabis, and I will find probable cause to detain you, sir. And I'll set bond at $100.
Judge, Mr. Lopez is kindly requesting to invite you into plea negotiations if you would consider offering him time served, considering this is a possession of cannabis misdemeanor offense.
I possibly would, but the first thing I notice is that he has active felony warrants.
Well, Judge, if he had active felony warrants, I'm sure that when they booked him or when he runs the NCIC, it would have came up, right? I mean, if he has active Broward warrants.
What indicates he has active Broward warrants, and
That's the that was the other person in the car, Your Honor. Benitez.
Okay.
Benitez has active, not Lopez.
Ah, okay. Do we have priors?
2015 grand theft with a VOP, 16-month state prison. 2004 possession of firearm or ammunition by adjudicated delinquent, carry and conceal firearm, VOP, 16-month state prison.
Of course, being invited to negotiations, and the request was
time served, Judge,
for an adjudication, and he's aware that an adjudication would give him a driver's license.
I did advise him he would be subject to a 2-year DL suspension.
Based on the priors, I was inclined to offer supervision, but it doesn't seem that he's a candidate for supervision with the 2 VOPs. So I will respectfully decline the invitation to.
Understood, Judge.
As pursuant to Williams v. State.
Thank you, Judge.
Thank you. Jesse Klee.
Mr. Klee is present, Judge. This is, I believe, municipal ordinance. Out of what city?
Daniel. Or the chosen one, Hollywood, Florida.
Hollywood. I believe it stems out of Hollywood, Judge. I don't know if you could inquire so that Your Honor could appoint Stephen Shate to Mr. Klee's municipal ordinance cases on count 1 and 2.
Good. He said, he wanted to put a female over there. I said, yeah, okay. Because I said, all the people do, they have it down for us. And they get it here. We got to look at it. If the school is taking classes, like,
All right, can we please place the defendant under oath?
What's that, Judge?
Please place him under oath.
Oh.
Sir,
What do
can
you say?
please raise your right hand.
Oh, raise your right hand.
You swear or affirm that
don't hear
everything you say
anything.
will be the truth?
Yes, sir.
Okay. And can you state your name for the record, sir?
Jesse Fitzgerald Clee.
Thank you, sir. You can place your hand down. Sir,
Are you on a bond or free trial?
are you currently employed?
I'm sorry?
No, sir.
Okay. And do you have any money in the bank or at home?
Not right now, no.
Okay. Who do you reside with?
I reside with my sister.
Okay. Do you pay rent there?
No.
Okay. And do you have any assets?
Assets? No.
Okay. I will appoint Mr. Shea on counts one, on the first two cases.
Live alone, what time are you friends? All right.
And, sir, I will find, well, actually, you have cases out,
You have children?
and that's in the amount of $100 on count one, 100, count two, 500, count three. And from the city towards the judge.
It'll have to get, unless he bonds out, it'll have to get reassigned to a judge in Central, Your Honor.
All right, sir.
Thank you, Judge.
And James West.
Mr. West is here, President of Maine.
Mr. West, good morning, sir.
Good morning, sir.
Sir, you have one count of resisting without violence that's been presented against you?
Yes, sir.
All right, sir, I will find probable cause to detain you. Any argument as to conditions of release?
Nothing from the state.
Nothing from the defense.
Okay. I'll set standard bond at $100, sir. Chastity, do you have anything you need to call out of turn? Joe Mitchell.
Judge, in speaking with Mr. West right now, he's asking Your Honor if you would consider being involved in plea negotiations and resolve his case today.
He has 3 separate cases, and I don't have those files before me.
Oh, he has
Those
separate
are 3
cases.
counts on one case. There's 3 separate cases.
I only see one count.
No,
He
they're
has
still
2
asking
other
on
pending
Joe
charges?
West.
Oh, I'm sorry.
Huh?
That was the,
They're resisting without.
I apologize. On the resisting?
Judge, I'm confused. Does Mr. West have 2 other open
No, it
cases?
was a previous defendant.
Oh, it's a previous defendant. Okay.
Yes.
Yes, I believe the only thing before us is Mr. West. It's a misdemeanor resisting without violence. He advised he cannot afford the bond, but he does wish to resolve the case if Your Honor would offer an adjudication time served.
I have taken a look at the probable cause affidavit, and I will, there are factors that cause the court concern. I'm leaving the bond at the standard bond, but I will respectfully decline the invitation into negotiations.
We appreciate that, Judge.
And I'm sorry, Mr. Hassett, you had
Joe Mitchell, Your Honor.
Mitchell. I'm looking for Mr. Mitchell's packet. Let's see. looking for the packet for Mr. Mitchell.
They should be all the way in the back.
Oh, okay. Unfortunately, I'm still not seeing it. Quite a few cases still in the docket. Let's see. Joe Mitchell. Mitchell does have an out-of-state hold. It's no bond.
Is
Like
he in,
count two.
is he here, Judge, or in custody?
Mitchell?
present?
Joe Mitchell.
Joe Mitchell is coming up. Mr. Mitchell, your attorney's there present?
You got a home where you roll with all the time?
Judge, I haven't had an opportunity to meet with him. I did meet with the family on the phone, and I'm asking that the case be reset for tomorrow. It's my understanding that because there's probably going to be an extradition matter, that it would be scheduled for tomorrow for that matter, and perhaps we could just put both matters over for tomorrow.
Let's see. When was the arrest made? Yesterday.
Do you have an attorney? Are you gonna hire your own, or do you wanna go?
I have no objection, Your Honor.
All right.
Like he's gonna put it in the second year of the business.
Mr. Mitchell. Sir, I'm
Yeah.
gonna reset your case for tomorrow. Okay, your attorney is present in court.
Yes.
Is he at the main jail?
Yes.
Okay, I'm going to come see you.
Okay.
Were you arrested by yourself?
And Judge, I just want to confirm, is the extradition matter going to be heard as well tomorrow at 8:15? Is that how it works?
If both are set for, if extraditions are tomorrow, then it both will be heard tomorrow.
Okay, all right, thank
It might be. I mean, there's no guarantee. I don't know if I'm just saying. Hopefully it'll be in the docket tomorrow morning for extradition.
All right.
I can't go any louder because the mic's around. You work.
And
If they've already set up on show,
Malera Simon.
they might be cut off.
Mr. Simon, come on up, please.
Simon, we have two matters before the court. One is a trespassing. We'll find probable cause to detain you on count one. Count two, sir, you have a bond. You have a bond that's been issued on case number 150000904 MM10A at $2,000. So on count one, I will set bond at $25, but you have a previously issued bond at $2,000. You also have, in the case with the $2,000 bond, you have a hearing before your assigned judge on 1/17/17, sir, at 1:30 p.m.
Thank you, Judge. Okay.
Shannon Veig.
Judge, I've been advised Shannon Veig bonded.
Joseph Gonzalez.
I've been advised he bonded.
Damian Dearman.
Mr. Dearman's present here in Maine.
There are two counts presented. One is possession of cannabis, one is resisting without violence. find probable cause to detain you, sir? Any arguments as to conditions of release?
No, Your Honor, I'm fine with the convenience bond.
Judge, no argument as far as the bond. At this time, I'd ask you to sign an order allowing us to photograph Mr. Dearman's injuries.
Okay, I'm gonna find probable cause on both counts and set bond at 100 on count 1 and 100 on count 2. And I will sign that order.
Thank you.
Marcus Jackson.
Your Honor.
Marcus Jackson?
Your Honor, I printed out.
13.
Your Honor, if I may. When Mr. Jackson was originally arrested, he was, as far as this offense, he was charged with robbery firearm. I've included a copy of the original PC and Judge Lernerent's findings. Since then, we have also charged him with additional counts of armed burglary, possession of firearm by convicted felon. I'm going to be relying upon the original PC also, seeking a no bond hold on count 6.
The information you just provided me has 3 counts.
Yes, if you look at when he came through, there were 2 PCs originally.
Right, I see count 1, 2, and 3, burglary of a non-occupied conveyance.
And the resisting was a separate matter. If you look at the PC affidavit, you'll see a robbery firearm, which was a standalone charge.
And that's count 6. That's the robbery firearm.
Yeah, the charge 6 on the booking sheet. No, charge 6 on the booking sheet would be, if you look at the information, count 2, the armed burglary. Counts 2 and 3 in the information are the add charges that make up charge 6 and 7 on the booking sheet.
And that would be the armed burglary and possession of firearm by convicted felon.
Yes, Judge. As you can see in the information, specifically count 2, it lists the same date and incident location that is on the probable cause affidavit.
The packet I have for me today does not include probable cause affidavit for count 6 or count 7.
I'm sorry, Judge?
The packet I have does not have a probable cause affidavit for 6 or 7.
Well, Your Honor, if I may, there was...
I have the probable cause affidavit that you presented me just now as part of the packet with the information.
There was never a probable cause affidavit prepared charging him with counts 2 and 3 because we charged those based on the allegations that are contained there in the probable cause affidavit.
And defense?
I don't have an argument as to probable cause.
And it's the conditions of release.
I'll defer to my colleague, Judge.
Judge, as far as Mr. Jackson's financial resources, he's been living in South Florida his whole life. He's 44 years old. He's working at Miramar Pickle. He was working there. He doesn't think he has that employment any longer. He was only making $8 an hour. Financially, he has no sort of resources, no money in the bank, no property. He doesn't believe that anyone financially can help post his bond.
And, Your Honor, while the state is seeking a no bond hold on count 6, he is entitled to a bond on count 7. To assist the court, his priors include 2008 robbery by sudden snatching. He was sentenced to 4 years state prison. 2008 possession of an imitation controlled substance with intent to sell or distribute, 4 years state prison. 2008 attempted home invasion robbery with a firearm, 4 years state prison.
And you're asking for a no bond hold on count 1, count 6?
Yes, on the armed burglary. Yes, Judge.
Okay. Are there any motions?
Judge, I'm not making a motion at this time. If he's being held no bond on a robbery firearm, I'm going to wait for an Arthur hearing.
All right,
And I just want to make clear I'm not moving for an Arthur hearing at magistrates.
I understand. I said no bond on count 6 and count 7. I will set a bond at $5,000.
And Your Honor does not need to issue no contact. It was ordered at his first appearance on the robbery firearm.
I will find state defendant's burden at this juncture. And Diego Velasquez.
Judge, he's over at the North Broward Jail.
North Broward.
Sorry. What's the name you're looking for?
Diego
Velasquez?
Yes, sir.
Right, come on, Velasquez, that is you. Here you go, North Broward. Johnson, let's go.
All right. Good morning, sir.
Good morning.
Yes.
Judge, may I make a brief argument?
You ready?
Just reading this, it seems that the co-defendant, I don't see anything there's allegations that he gave statements to the detective. Seems like that there's some form of cooperation. But anything here indicating that he assisted, encouraged the robbery that Mr. Weston did to take place, or that he actively was helping him doing that? I apologize. I withdraw my argument. It says he got out of the car too.
And began to assist with the robbery. Okay. And as
Judge, he's being held on count 1 on a $25,000 bond with a pretrial release. Elmo, the Judge Singal.
oh, this is an ad charge.
This is an ad charge for robbery, no firearm, so he's entitled to a bond.
Okay, this is a standard robbery, and
Judge, I could tell you this: his mom is working to bond him out on count 1. He doesn't have many ties to Broward County. He's from Homestead. His mom does work in the field. She picks fruits. She's trying to gather what she can to bond him out. He was doing construction. Things in the construction business these days are slow. He was living in an apartment out there. It's not much he can afford in bond. I would ask the court to set a reasonable bond.
Your Honor,
I'm sorry. Last thing I just don't want to say, just want to note the last paragraph. And court could take that into consideration for mitigation. the last sentence.
Your Honor, I just want to advise the court a very brief summary of the allegations for the attempted burglary that he's being has a $25,000 bond on. That also involved Mr. Wesson, where they went to a locked business, trying to open the door using a pry bar and a sledgehammer. When they were unsuccessful in getting in, and it's an attempted burglary, Mr. Wesson actually shot a firearm at the door, locked door, in attempts to open the door that way. Your Honor, considering this is additionally a separate incident, and it appears that a pattern was forming, I'd be asking for a $25,000 bond on this charge, with the same release conditions as charge one, pretrial release, GPS level 1.
$25,000 bond. He can't afford it on count 1. He want to be able to afford it count 2. I think it's.
I will find probable cause to detain him. I did allow the initial argument. I'm going to set bond at $15,000.
Yeah, I'm sorry. He is. Well, I just want to show you. You just want to look here real quick. Well.
Okay, if he is currently on pretrial, the pretrial will run concurrent on this count. If he's not on pretrial, then I'm not going to order pretrial solely on this count. Okay.
No, all I was showing you was.
And it'll be pretrial with the same conditions as the previous counts. $15,000. Good luck, sir.
What's written on the affidavit, that's why I was looking for the written control. Apparently what's written on the affidavit when he did it. I'm sorry.
No problem. And Kadeem Johnson. Kadeem Johnson?
Johnson?
I didn't hear you, Judge.
Kadeem Johnson.
North Broward.
I can leave? Yeah, you can go.
Mr. Johnson, good morning, sir.
Good morning.
Sir, you have one count of burglary of a dwelling that has been presented. Looks like an ad charge.
May I ask where this charge come from? Well, yeah.
Sir, I'll call you and tell you what they're saying.
The allegations stem from a June 10th, 2015 incident. Do not respond. I'm just letting you know. Okay? And I will find probable cause to detain you, sir. As to count 1, count 4 technically. Any argument as to conditions of release?
Your Honor, just to advise the court, I'm going to be asking for a $15,000 bond. This involves someone's home. He's being held on local charges for $1,000 on a grand theft auto, $1,000 on a battery KPS, and he's got out-of-state holds for burglary, wire fraud, burglary, escape involving, I guess he was on electronic monitoring and cut it off or removed it, and wire fraud and identity theft, and those are no bond holds out of state.
Judge, I didn't get a chance to speak to him in light of the fact that he's being held no bond on other counts, so I would ask the court to set a reasonable bond.
All right. This count, and based on what I've heard so far, I will set a bond at $20,000 on count 4. Counts 5 through 9, sir, are out-of-state holds, and you have no bond holds on those counts. You understand that, sir?
Yeah.
All right.
Yeah, I understand.
You probably want to talk to an attorney before you speak to me, because everything you say is being recorded right now. You understand that?
Yeah, I understand. I just didn't know what this was for.
Okay.
Yeah. That's why I asked like what it was for. Cause I ain't even know. They just called me out my sleep and brought me here. You know what I'm saying?
They'll call you, and they'll explain. If I go into detail, you may say something against your.
Sir, just go by the phone. They're going to transfer you to me. I'll tell you what they're alleging.
All right.
And I'm also ordering no contact with the victim, no return.
I need that one back. Yeah.
All right. Orion Green.
Judge, he's here at Maine.
Your Honor, he was here yesterday. It was charged for the allegation involving the second alleged victim, Your Honor. Bond, he was here yesterday on one count of battery, one count of burglary of an occupied dwelling. Bonds were set at $15,000 each, plus pretrial release GPS monitor.
There will find probable cause to detain you. Any arguments from the defense as to conditions of release?
I believe, judging from yesterday, as Mr. Lender said, he was given $15,000 on each count. We'd be asking for on the third count $15,000 as well.
Okay, we'll issue a bond at $15,000.
$15,000.
It's 1-5.
Thank you.
15,000. The one we just Rodney Estelholm.
Mr. Esselholm?
Decline PD.
Judge, I've been informed Mr. Esselholm declined the service of public defender.
All right. Good morning, sir. How are you?
Good morning.
Do you have an attorney? That was a no?
No, sir.
Okay. And you don't want to see you qualify for a court-appointed attorney, is that correct?
No, sir.
Okay. Sir, you've been charged by with one count of possession of ammunition by a convicted felon, and
I got her. No, we're good on that one.
find there's probable cause
Thank you.
to detain you. You also have on counts 2 through 6 out-of-county holds that are no bond holds.
Mr. Paz Torres?
And I will set bond on count 1 at $5,000.
All right.
Hello, sir.
Joe Gibbs? Come on up, Mr. Gibson.
Mr. Gibson.
Decline PD.
Joe Gibson declined the service to public defender as well, Judge.
Mr. Gibson, you have a violation of probation.
Yes, sir.
And the signed judge has set your bond at no bond.
I understand.
You have a hearing on January 17th at 3:30 a.m., sir, for your signed judge, okay?
Okay.
All right, make sure that you'll see your signed judge, sir. Okay?
Okay, thank you. What did you say?
Eric Diaz. Mr. Diaz. Good morning, sir.
Good morning.
Saying that they have a hold in Brevard County. I haven't even.
Of course.
They're saying they can't allow me because I have.
Judge, Mr. Diaz is advising me that he's already posted bond. I don't know if confinement status can verify.
No, they're saying I have a hold.
We're checking.
Okay, they're checking.
It might have gotten returned. He's got a Brevard County hold. Okay.
It doesn't show that you bonded.
Okay. It does not show he bonded?
Correct.
They're not allowing the bonds here because of the hold, and I never even been to Brevard County.
That's what I'm showing in the system.
Mr. Diaz is advising that he does not, attempted to bond out. They advised him that he had a Brevard County hold. He's completely confused as to the hold.
I've never been to Brevard.
Okay.
And it's not on the docket.
What we have on the docket today are 2 counts: possession of amphetamine, possession of cannabis.
No.
Sorry, it's synthetic cannabis. I apologize. Over 3 grams. And I will find probable cause to detain you, sir. And any arguments as to conditions of release?
Nothing from the state, Judge.
Judge, Mr. Diaz, no argument. He's gonna, he believes he can post his bond. The only thing he's worried about is the Brevard hold.
Okay. On these counts, I'll set bond at 1,000 each. 1,000 count 1, 1,000 count 2. Robert Henner, Hannor. Sir, good morning.
Yes, ma'am.
In charge of violating your probation?
Yeah.
Mr. Hanner?
All right, bye.
Okay. Mr. Romero has his hand on the microphone, so I can't hear you.
Sorry about that, Judge.
It's okay,
Sorry
Mr.
about
Romero. Mr. Hanner, in charge of violating your probation, you have a no bond hold that has been set by your assigned judge. You have a hearing on January 18th at 8:45 a.m.
All right, thank you.
Good luck, sir. Joshua Santiago. Mr. Santiago, good morning, sir. You likewise have a violation of probation, and your assigned judge has set bond at $1,000. Sorry, I apologize. No bond.
No bond. No bond.
You have a hearing on January 17th at 8:30 a.m., sir.
Write that down for me on this paper.
Santiago?
Yes, sir.
Okay, you have a court date, January 17th, just as the judge said, at 8:30 in the morning. Judge Robinson, okay? You'll be taken there. Here you go.
Thank you so much.
Okay. Thank you, Judge.
All right, and James Silva.
Mr. Silva, come on up, please. Page 15.
So you have a violation of community control that's been filed, and it looks like your assigned judge set bond at no bond. You do have a hearing set in 2 days, on the 13th, sir, and that's at 9 a.m.
Thank you. All right, thank you. Darnley Morrell?
Good morning, Judge.
Good morning, Mr. Morrell. How are you, sir?
I'm all right. How about yourself?
Doing well, thank you.
Judge, Mr. Morrell advised me that he has private counsel, Terrence Moon.
I don't have Mr. Moon present this morning, sir. But right now, you have 3 counts presented against you. Count 1 is driving with license suspended as an habitual offender, possession of a weapon or ammunition by a convicted felon, and an out-of-county civil hold for $1,500.
¿Tienes medicina? ¿Tienes posibilidad? ¿O no te arrestaron? ¿La policía te hizo daño?
Sir, we'll find probable cause to detain you. Did you advise your attorney at this hearing?
Your Honor, I have not having a chance to use any phone or anything yet.
And so have you hired him on this case?
No, that's just my regular attorney that I
Okay,
use in prior cases.
Okay, so you plan to hire him on this case?
Right.
Okay.
Do you have an attorney?
Right now, you have no attorney.
I'm sorry?
As it stands,
Are you gonna hire your own, or do you want to?
as you sit here before me, you have no attorney. So
At this moment, yeah, correct.
At this moment. On count one, sir, I'm going to set bond at, I'm finding probable cause on all 3 counts. Count one, I'm setting bond at $750. Count two, I will set bond at $5,000. And count 3 is an out-of-county hold that's already been set at $1,500, sir. Okay?
All right, thank you, Your Honor. Have a good day.
You as well, sir.
Further bond.
Evans, Jean-Pierre. No relation.
North Broward.
Good morning, sir.
Good morning.
Well, I'm going to begin with counts 4, 5, and 6, sir. You have a violation of community control for felony. Each count on 4, 5, and 6 has been set at no bond by your assigned judge. And as to count 1, I will find probable cause. Count 2, I'll find probable cause. And count 3, I will find probable cause. I'll set bond on count 1 at $1,000. Count 2 at 100, and count 3 at 0. Count 5, it does not belong to this defendant. Okay, so sir, I'm striking count 5. I've been informed that it does not apply to you, but you still have a no bond hold on counts 4 and count 6. Okay?
All right. So I gotta see when I see my judge.
You have a hearing on 1/17/17 at 9 a.m., sir.
All right.
Mr. Rodney Squire.
Mr. Squire is here present. Judge, he declined to serve as public defender. He plans on retaining private counsel Teresa Williams.
Your Honor, assuming the court finds probable cause, if I could be heard regarding release
Do you
conditions.
owe anybody on the credit cards, hospital bills, all your rights?
Where's Mr. Squire?
Is it Maine?
Right here, sir. Good morning, sir.
Maine.
Good morning, sir.
Good morning, sir.
So right now you don't have an attorney. You have not hired an attorney in this case, correct?
Well, my family went to go hire her this morning.
Okay, but right now you don't have an
She's
attorney.
She's not present. No.
No, okay, so you don't have an attorney as of right now.
Your phone number.
So you're aware, sir? Count 1 is a violation of community control for a felony, and it's been and the assigned judge said that no bond.
Yes, sir.
Counts 2 and 3 are aggravated battery with a deadly weapon and possession of ammunition or a firearm by a convicted felon. Sir, I will find that there is probable cause to detain you. In reference to being heard, Ms. Linder.
Your Honor, one, I want to advise the court it appears that Mr. Squire, pursuant to Florida Statute 94806, is a violent offender of special concern. I know it mentions on the booking sheet attempted felony murder. I just want to advise the court he's also on probation for aggravated battery, serious bodily injury, and attempted robbery with a firearm. It's under the same case. He was placed on 6 years probation by Judge Levinson on July 8th of 2016. Taking into consideration the charges he's on probation for and the potential consequences he faces if found in violation of his probation as a violent offender of special concern. And additionally, the allegations in this case, he is a co-defendant of the woman we had earlier on the docket. He's alleged to have been one of the 2 gunmen that shot the victim 6 times, Your Honor. I'm going to be asking for a $250,000 bond on count 2, a $50,000 bond on count 3, and no victim contact, and no contact with co-defendants.
Okay, have a repeat before.
All right, do you hear that, sir?
Yes, I hear, sir.
I will set a $200,000 bond on count 1. Sorry, on count 2. But I will set a $10,000 bond on count 3. You are already being held no bond on count 1. You had a hearing before your assigned judge on January 17th. And that
Yes,
is
sir.
at 8:30 a.m., sir. Okay?
Yes, sir. Yes, sir.
And, Your Honor, as far as the no contact orders?
And I will order no contact with the victims or their families. And
Yes,
no
sir.
contact with the co-defendants in this case.
Yes, sir.
All right,
Yes, sir.
And can't choose aggravated battery with a deadly weapon.
Mr. Hudson?
200, I believe.
And
Do you have one?
you understand what no contact means, correct?
Are you gonna do?
Yes, sir.
No contact means no direct, indirect, electronic, telephonic, no social media, and no contact at all.
Yes, sir.
Their families are co-defendants. You understand that?
Yes, sir.
Okay, sir. Good luck.
All right, thank you.
Hold on, for the paper with you. Both hands down, sir.
Actually, I apologize, Mr. Squire.
Squire. Mr. Squire.
Were you arrested by yourself? Who was arrested with you? I'm sorry?
Judge, recalling me. Sir.
Who is it? I need you to say the name.
I apologize. There's another document here, sir. It's been set at no bond on all counts, but by the assigned judge, by Judge Forth. You signed an order.
Yeah, Your Honor, Judge Port did set it at no bond. In all candor, though, he is legally entitled to a bond. Judge Port is not the judge assigned to the case. I think this is going to be with Judge Rothschild because he has the probation, but he is legally entitled to a bond.
Okay. All right. Then, based on what the state has just advised the court, I'm going to leave the bond as I previously said it.
Yes, sir.
But you understand another judge did sign an order saying no bond. Okay?
Yes, sir.
All
Yes,
right,
sir.
Good luck.
All right. All right.
And Melvin Pagan.
Mr. Pagan, come on up, please.
On that black wall, move in that road.
Yeah.
Sir, you've been charged with violating your probation on case number 15010979 CF10A. The bond has been set at $3,500, sir. You'll be hearing before your assigned judge on January 17th, 2017 at 8:30 a.m.
Thank you, Judge. That's it? Yep, that's it. Where's your book? Enter Benitez?
Enter Benitez. Good morning, sir.
Good morning, sir.
counts that have been presented.
You're arrested by yourself? You have any children?
I will find probable cause to continue on count one. I'm setting bond at $100. Counts 2 and 3. You have felony cases that have already been set at no bond holds on each. Except for failure to appear. Okay, sir?
Yes, sir.
Good luck, sir. You have a hearing on the 23rd of this month at 8:30 a.m. before your assigned judge.
Yes, sir.
Nico Gollins.
Mr. Gotts, I see you're present at Maine.
Good morning, sir. You have 2 counts that have been presented. One is petty theft, the other is possession of an anti-shoplifting device.
Judge, Mr. Goss is informing me he does not hear so well from his left ear. If you could speak up a little bit.
Sir, can you hear me?
I can hear you now, sir.
Okay, you have 2 counts. One is petty theft.
Yes, sir.
As, it's a second-degree misdemeanor. The other count is possession of a anti-shoplifting device. Okay?
Yes, sir.
And I will find probable cause to detain you, sir.
Yes, sir.
I'll set bond at $100 on count 1 and $1,000 on count 2.
Thanks, Judge.
You're welcome. Sir, were you able to hear that?
Were you able to hear that he said $100 bond on count 1, $1,000 bond on count 2?
Yes, sir.
He did.
Okay. Good luck, sir.
Thank you.
Ernest Chandler.
Mr. Chandler, come on up, please. Oh, I've been informed Mr. Chandler bonded. Mr. Kanaya Gale is here present, I mean?
Gale. Morning, sir.
Morning, sir.
Yes. That's our case.
Your Honor, will the court consider placing the gentleman on pretrial release?
His information has been verified, Your Honor. The court is inclined to release him to us. I spoke with his father.
I believe he said he's going to try and contact a friend to post his bond.
So he's not interested in pretrial release?
No, he's gonna try and call a friend and see if they can post his bond, Judge.
Thank you very much. Sir, I'm going to find probable cause on both counts. Count 1, I'll set bond at $1,000. Count 2, I'll set bond at $500.
Thank you, Judge.
Thank you, Judge.
Masach Navone Jones?
Shaq Jones.
What is your request number?
Sorry, Your Honor.
Do you work? Is your honor? You get a person from the government, what's your name, final work and time? What you get? Do you own private account?
Morning, sir.
Morning, sir.
You've been, one count of violation of parole has been presented,
Circle the nose
and there is a no bond hold, sir.
Yes, I understand, sir.
Okay.
Thank you, Judge.
Good luck, sir. Juan Ortiz?
North Broward.
Mr. Ortiz, good morning, sir.
Good morning, Your Honor.
So you have a violation of probation that's been presented, and
Yes.
from a 2009 case, no bond hold has been issued by your assigned judge. You have a
All
hearing
right.
before your assigned judge on January 17, 2017 at 8:45 a.m.
All right, thank you.
You're welcome, sir. Good luck.
Thank you.
Johan Nami Izami.
Mr. Izami bonded, Judge.
Last one.
James King.
Mr. King is present here at Maine.
Good morning, Your Honor.
Morning, sir. All right, sir, you have a violation of probation that's been presented, and the bond has been set by your assigned judge at no bond. You have a hearing on January 17th at 9 a.m. before your assigned judge.
Thank you.
Thank you.
Brian Ahern.
No, outside the home.
Ahern.
Morning, sir.
Morning, sir. You have a violation of probation as well. On a 2012 case, the judge set a no bond hold, and you have a hearing on January 17th at 9:45 a.m. before your assigned judge.
Thank you.
Thank you, sir.
Gerard Barone. Gerard Barone. He's coming up, Maine.
Morning, Your Honor.
Sir, you also have a violation of probation. On a felony 2015 case, your judge has set a no bond hold, and you have a hearing on January 18th at 8:45 a.m.
Okay, yeah.
Good luck, sir.
Thank you.
Thank you.
Anthony Hankerson.
Mr. Hankerson. Good morning, sir.
Good morning.
Courtroom. Okay, Deputy Bailey.
Sir, I will find probable cause to detain you. You have 3 counts. One is possession of cocaine, the other is possession of cannabis. Possession of synthetic cannabis, I apologize, and then a violation of community control. The violation of community control has a no bond hold set on it. Count 1 has a $1,000 bond, and I'm setting the bond on count 2 at $500, sir.
Judge, and speaking Mr. Hankerson, would you sign a phone order allowing him access to his phone numbers in order to contact his family and let him know where he's at?
Under the supervision of law enforcement, he may have access to view his phone.
Yes, Judge.
We need a short order to that effect, and you have a hearing on January 17th at 8:30 a.m., sir.
Thank you.
Luis Paz Torres.
Paz Torres? English, Spanish, Espanol? Judge, we're going to need a Spanish interpreter for Mr. Paz Torres.
And we don't have one this morning. All right. On recall.
We'll see.
Yes, because they may send it. They may go to my courtroom.
Yeah, you go.
She
I do have a docket this morning.
Not anymore.
Not anymore?
They just emptied it out.
Okay.
Got no one to run. They just closed the doors.
Gamar Mosikil.
Mr. Muskiheel is here present at Maine. He declined to serve as public defender.
Sir, you declined the services of the public defender?
I mean, I actually did. I think it was a misunderstanding, though.
You want?
If he wants to reconsider, he could go ahead and fill out a financial affidavit this morning, Judge. I'll have him fill it out, and I'll help him through this magistrate hearing, Judge.
Is it a recall or?
No, we can go for it.
All right. Any arguments as to probable cause? Merrill?
Judge, at this time, nothing to add as far as the defense.
Okay.
Your Honor, just to advise the court, 2013.
Well, before we get to that, on probable cause.
Was there? Yes. Yes, sir. Was there an? I didn't know if the.
Does the state have anything to say in reference to probable cause?
No.
Now that there's a defense.
Not in reference to probable cause, I would defer to my colleagues as far as if there's any probable cause arguments to be made.
Thank you.
I'll find probable cause for possession of cocaine.
Your Honor, that being said, I'm still going to ask for the $2,500 bond at a minimum. Defendant in 2000 had a carjacking without a firearm or deadly weapon, attempted carjacking out of Palm Beach. He was sentenced to 3 years state prison, and he was just released from state custody April 10th of last year.
Judge, Mr. Mazakil just obtained employment. He's working at Big Ray's Barbecue. He cleans. He only makes $9.50. He hasn't had time to accumulate any sort of financial resources. He has no money in the bank, no property. He lives in Lauderhill with his parents. He is hoping that his parents can somehow financially be able to post his $2,500 bond. We'd ask you to keep it at $2,500 bond, considering Mr. Mosakil's financial resources, Judge.
Given that I found it probable cause on possession of cocaine rather than possession with intent, I'm going to set bond at $750.
Thank you, Judge.
Zachary Watson.
Mr. Watson, come on up, please.
right, so you have 5 counts that have been presented against you, 1 count of possession of cocaine with intent to sell, 1 count of possession of cannabis, and 3 counts of possession of drug paraphernalia. Any arguments from either party?
I believe, Judge, this is the co-defendant on the last case that I believe you only found probable cause for simple possession.
Mm. This is the last case. $750 bond from here. I mean, that's it right there. Your Honor, and I can tell you, and frankly, I wish I had this information for the other co-defendants. This was written by a different officer, but it does mention an electronic scale where that field tested positive cocaine residue was found on was located.
There's more information on this probable cause affidavit than the other case in reference to this defendant. So we'll find probable cause on count 1. The bond is $2,500.
Judge, I believe, I don't mean to interrupt the court. From what I heard from Mr. Lunder, they found, I guess, a scale in the vehicle. I just want to point out that Mr. Watson is not the owner of the vehicle, and he was a passenger in the vehicle, not the driver.
Your Honor, considering that it was found in plain view, the court can make a finding at this point in time for PC for constructive possession.
Not only was it in plain view, the probable cause indicates that it was directly next to him on the seat, along with the baggies, the scale, 4 plastic baggies. And 2 straws containing residue. Looks like everything was found next to this gentleman.
I believe there was other occupants in the vehicle, but I know probable cause is very low burden. So, Judge, if you determine there's probable cause, then we have no further argument.
Okay, I will find probable cause on counts 1, 2, and 3, as well as 4, but I will not find probable cause on 5. And I'll set bond on count 1 at $2,500, count 2 at $500, count 3 at $250, count 4 at $250, and I did not find PC on count 5.
Judge, even though I know you found probable cause, considering the strength, or as the defense would say, the weakness of the case, would you consider reconsider count 1 from the $2,500 bond to $750 bond?
2014 possession of marijuana, 2013 possession of marijuana, 2011 possession of marijuana, 2008 burglary of a conveyance and felony theft, 17.5 months state prison, 07 burglary of a structure, grand theft, resisting without violence with a violation of probation, 17.5 months state prison, 07 burglary of a structure and grand theft between $10,000 and $20,000 with a violation of probation, 17.5 months state prison.
Given that information, Mr. Linder actually provided ample argument to increase the bond, but I will leave it at this, as I previously pronounced.
Appreciate it, Judge.
We have court interpreter here on Mr. Paz Torres.
Suárez. Señor Suárez.
Paz Torres.
Mr. Suarez. Mr. Suarez.
Will you please?
Paz Torres. Paz Torres. Perdón.
Paz Torres.
May you raise your hand? Do you swear to tell, translate to the best of your ability from Spanish to English and English to Spanish?
Yes, I do, Silvia Orozco.
Good morning.
Buenos días.
Mr. Paz Torres. Good morning, sir.
Señor Paz Torres, buenos días.
Buenos días.
Good morning.
Sir, you have 3 counts presented.
Tiene 3 cargos.
Failure to stop or remain at an accident.
No parar o permanecer allí en un lugar del accidente.
Operating a motor vehicle without a valid driver's license.
Conducir un vehículo sin una licencia válida.
And failure to use due care.
Y no utilizar el cuidado debido.
State, I don't have any citations.
Hold on a second. I'm sorry, Your Honor?
I didn't have any citations, so
Yeah, there's...
I will find probable cause on
Encuentro que sí existe la causa probable
count 1,
del cargo número 1.
and I will not find probable cause on 2 or 3. I don't have any information on those.
Y el 2 y 3 no tengo la denuncia clara sobre esos 2 cargos.
And I will set bond at $2,500, sir.
$2,500 es la fianza que le impongo, señor.
Judge, would you consider lowering it if the state can verify? I believe this may be Mr. Paz Torres' first arrest, Judge. He works in construction, making $10 an hour. He lives in Pompano in a mobile home. He's been residing at the same location for a year and a half. He lives with his sister. His expenses just in rent is $400. That does include electric, water. Judge, we'd be asking you to consider a $1,000 bond on count 1.
Based on the allegations in the probable cause affidavit,
Basado en los alegatos y en la causa probable, en el affidavit de la causa probable, impongo esa fianza. El señor, por favor, señor juez, considere reducirle la fianza de $2,500 un poco. El señor vive en Palm Beach, en Pompano Beach, trabaja en construcción, paga $400 de renta solamente sin contar con los servicios ni electricidad. Y entiendo que esta es la primera vez que tiene esta acusación de conducir sin licencia.
Thank you, sir.
Gracias, señor.
Thank you.
Thank you, Judge.
You're welcome.
And Willie Hudson. Hudson, good morning, sir.
Good morning.
There are 2 counts presented. One is driving with license suspended, third a subsequent offense, and disobeying a stop sign. All right, I will find probable cause to detain you, sir.
Defendant is currently being supervised by pretrial services in case 15-1-526 for possession of 15-1-2-526.
As CF10A?
Yes, based on the corresponding on probable cause, we ask that this pretrial status be revoked at this time.
All right. I will revoke his pretrial status, his release status, and set no bond hold on the possession of cocaine on case number 15-1-526 CF10A, and I will set bond on this case on count 1 at $750, count 2 at 0. The order is reviewable by the trial court. Woody Morency.
How many to Alexander Brown?
Okay. Mr. How do you pronounce your last name, sir? Marisi? Morency. Mr. Morency is here present at Maine?
Good morning, Judge.
Good morning, sir. How are you?
Not so good.
I understand, sir. All right, sir. I will find probable cause to detain you on count 1, and I will set bond at $100. However, you have 2 violations of community control, and both have no bond holds previously set. You'll have no bond holds on counts 2 and counts 3, and a $100 bond on count 1.
Thank you, Judge.
Alexander Brown.
Judge, I have no paperwork on him.
On Alexander Brown?
No.
And Judge, he declined to serve as a public defender. He's planning on retaining Mr. Michael Ahern.
Okay. So did you hire an attorney as of yet?
Yes, sir.
You already contracted with the attorney for this case?
Yes, sir.
When did you speak with the attorney?
I turned myself in last night around 9 o'clock. Before I turned myself in, I spoke to him.
Did you advise him of this hearing?
Excuse me?
Did you advise him of this hearing?
No, he doesn't. He knows everything that's going on right now.
Okay, so you're proceeding today without your attorney?
Yes.
Okay. I see that there was an arrest warrant previously issued by Judge Singal, and the bond was already set at no bond.
Your Honor, because this is a punishable by life offense, the state would be seeking a no bond hold and no victim contact based on the allegations in the warrant affidavit.
So, do I have?
The no bond hold as well.
Okay. Do I have a hearing date?
Right now, you have a no bond hold. We're going to set a hearing in front of Judge Singal. Well, actually, in front of your assigned judge. Judge Singal may have signed it as a duty judge. And Madam Clerk, do you know when the court date is?
It'll be up to his attorney to file the appropriate motion.
It'll be set before your assigned judge, sir. Okay.
Okay. Appreciate it.
You're welcome, sir. Mr. James Rowan.
Mr. Rowan here present at Maine?
All right. I will find probable cause to detain you on all 3 counts. Count 1 is grand theft auto. Count 2 is leaving the scene of an accident with a property damage or injury. Count 3 is driving with license suspended, first offense. I'll set bond on count 1 at $1,000. Count 2.
Your Honor, and Mr. Rowan basically has no sort of financial resources. He's going to try and contact somebody to see who can possibly post bond on count 1. I'd ask you to leave count 1 as it is and leave counts 2 and 3 as the standard bonds where no bond is required.
Count 2 I'm going to set at $500. I'll leave count 3 at 0.
Thank you, Judge.
Thank you. Eddie Johnson. Good morning, sir.
I don't know, sir.
I'll start off by indicating that you have a capias that's been issued in count 4 in the amount of $500. And you have 3 other counts that have been presented: petty theft, possession of heroin, and trespassing.
You sure they got the right one?
All right. Sir, I will find that there is probable cause to detain you.
Judge, in speaking with Mr. Johnson, he is 66 years old. He's been residing in South Florida his whole life. He lives in West Park. He lives with his cousin. He's been residing in the same location for the past 9 years. He's not working, no money in the bank, no property. The only thing we'd be asking you to do is on count 2, would you consider lowering it from $1,000 to $500?
Well, I mean, Your Honor, my concern, he's here on count 4 because he didn't go to court to begin with. His last privacy, 2014, he was for violating a domestic violence injunction. He's been to prison for possession of cocaine. He's had 2 prior thefts. I think $1,500 is a reasonable bond, considering.
All right. Mr. Mero, having heard that, in addition, count 4 is a failure to appear.
I understand there's a failure to appear capia. That's why I'm not even asking anything in reference to count 4. I know Mr. Johnson did tell me he went to the Hollywood courthouse, and when he went there, he realized he went there on the wrong day. But that's why I'm not even going into count 4. I'm just referencing in count 2, considering Your Honor's lack of financial resources. I'd ask you just to once again consider lowering it to $500. And I don't even know if he'll be able to make that. He has to contact his cousin.
Okay. I'm going to set count 1 at $100. Count 2 will remain at $1,000. Count 3, I will set at $100. And count 4 has already been set at $500. And I will also order, sir, that you not return to the Walmart located at 301 South State Road 7. That's in Hollywood, Florida, sir.
Okay.
Gotta make a phone call, 2 phone calls.
Oh, you need access to your phone? Let me ask the judge. Judge, Mr. Johnson is requesting you would sign an order allowing him access to his phone so he can contact his cousin. He doesn't have the phone number memorized.
I'll send an order allowing him to view his phone under the supervision of law enforcement. However, I will not allow him to make a call with the phone.
Okay.
Because I did hear the conversation.
Okay.
You weren't silent on that one.
No problem.
Harvey Moyes.
North Broward.
Good morning, sir.
Good morning, sir.
So you have three counts that are presented. One is loitering and prowling. You had two violations of probation, or two violations of community control. The violations of community control have no bond holds.
I think these are old because I'm not on community control anymore.
Yeah.
I'm on only probation. I think these cases are old. They never took them out because I used to have those cases.
They're currently set at no bond holds, sir. So you still have the holds that have not been satisfied.
Yeah, they listed as community control and or probation
Okay.
on the booking.
All right. Count 2 and count 3 do, in the way they read on the hold, it's probation violation or community control violation. Okay, and it's for a felony.
All right.
All right. Now we'll find this probable cause to detain you on count 1. I'll set a $25 bond. Count 2 and count 3 have no bond hold, sir. And we'll set a hearing before you're assigned judge, okay?
Yeah, back and forth.
Good luck, sir.
I think that's it.
Is there any other?
I think so.
All right. Thank you, ladies and gentlemen. 1:30.